Let me start with something that feels completely normal. Someone you trust, maybe an adult child like Susan or Michael, maybe a caregiver like Denise, maybe even a close family member like your nephew Robert, sits at your kitchen table or hospital bedside and says, "This will just make things easier if something happens." They tell you it is only paperwork. They say it is for your protection. They say everyone does it. And in that moment, it feels reasonable. It feels responsible. It feels like the grown-up thing to do. Here is the thing. Hidden inside that very ordinary moment is a legal shift that many seniors never see coming. A power of attorney can quietly transfer control over parts of your life long before you believe you are giving anything up. Most people never notice this until after the fact. And this conversation is not about fear, it is about recognition. It is about realizing that trust and protection are not the same thing. Stay with me because this is important. My name is Judith Carver. I am a senior protection educator. I am not a lawyer, and I do not provide legal advice. My role is to help older adults understand common legal and financial situations so they can avoid costly mistakes, confusion, and unnecessary stress. Laws vary by state, and only a licensed attorney or qualified professional can give you legal advice specific to your circumstances. What I do here is educational. I explain patterns, risks, and protective steps so you can make informed choices. This work exists for one reason. Too many seniors like Helen, Frank, and Doris are asked to sign things without clear explanations. And I believe strongly in this principle. Your rights do not expire with age. Let us slow this down and talk plainly about what a power of attorney actually is. In simple terms, it is a legal document that allows another person to act on your behalf in financial or legal matters. That could include paying bills, accessing bank accounts, managing investments, or dealing with property. What most people do not realize is that depending on how the document is written, that authority can begin immediately, not later. Not only if you become ill, right away. This is the part nobody talks about. Many seniors like James or Patricia believe they are planning for a future emergency, when in reality, they are handing over present-day authority. Imagine signing during a hospital stay, groggy, overwhelmed, trying to be cooperative. The emotional consequence often comes later when decisions are made without your involvement. Timing matters more than intentions. Now listen carefully. One of the most important protective tips is this. Never sign a power of attorney when you are rushed, tired, medicated, or emotionally overwhelmed. This sounds obvious, but it happens every day. After surgery, during a medical crisis, in the middle of family pressure. Here's where it gets interesting. Not all powers of attorney are the same. Some are narrow, some are broad. Without using legal jargon, this means some documents allow help with one specific task, while others open the door to almost everything you own. Bank accounts, retirement funds, property, even the ability to change beneficiaries in some states. Let me show you exactly what happened in one common scenario. A woman named Margaret wanted her daughter Linda to help pay utilities while she recovered from an illness. The document she signed allowed far more than that. Linda never intended harm, but legally, she could have sold property without asking. The emotional consequence is shock when you realize how much authority was granted. Words on paper matter more than intentions. So here's another practical tip. Always ask what exact powers are being granted. Ask for explanations in plain language. And then do something very important. Repeat back what you believe the document allows. Now let us talk honestly about family and caregivers. Most people never notice this part. The majority of problems do not start with bad intentions. They start with stress, money pressure, confusion, a caregiver who thinks they are entitled to reimbursement, a family member who believes they know what is best. Picture a caregiver named Carla paying herself back for groceries without keeping records, while Mr. Thompson assumes everything is fine. It feels minor. It adds up. And suddenly there is conflict, suspicion, and hurt feelings. The emotional consequence is family damage that lasts longer than any document. This is where it gets uncomfortable, but stay with me. Powers of attorney are usually not monitored by courts. That means there is often no automatic oversight, no regular check in, no built in review. Transactions can happen quietly, small withdrawals, subtle changes. Over time, the impact grows. Imagine noticing a few $100s missing each month and assuming it is a mistake, like Mr. Harris did for nearly a year. By the time questions are asked, significant damage may already be done. So here's another practical tip that matters. If a power of attorney exists, require regular written accounting, not because you expect wrongdoing, but because transparency protects everyone involved. Clear records reduce misunderstandings and discourage poor decisions. When expectations are set early, relationships stay healthier. Seniors like Carol or Dawn often say they finally slept better once everything was written down. Now let us talk about revoking a power of attorney. This is something many seniors misunderstand. Yes, it can usually be revoked, but only while you are mentally competent, and it must be done properly. Written notice, correct distribution, sometimes filing. I have seen situations where someone like Evelyn sensed something was wrong, but waited too long. Once capacity is questioned, options shrink quickly. The emotional consequence is feeling trapped by delay. Timing protects choice. Now let us talk about something that catches many people off guard. Laws about powers of attorney are not the same everywhere. What applied to your neighbor in Florida may not apply to you in Ohio or Arizona or Pennsylvania. Seniors like Robert or Janice often say, "My friend did this and it worked fine." Here is the brutal truth. State law controls how authority is granted, how it can be limited, and how it can be challenged. Assumptions based on someone else's experience can lead you into trouble without warning. This brings us to one of the most important protective steps you can take. Always consult an independent legal advisor before signing a power of attorney. Independent means chosen by you, not arranged by the person who will receive the authority, not rushed through during a family meeting. Seniors like Eleanor or Thomas often feel awkward insisting on this, but independence changes everything. A licensed attorney can explain options, tailor limits, and make sure your voice is the loudest one in the room. The emotional consequence is peace instead of pressure. The punchline is clear. Independence protects dignity. Another practical tip matters here. Take documents home before signing. Read them slowly. Put them down. Pick them up again the next day. Seniors like Harold or June often say they notice things on the second read that they missed the first time. There is no prize for signing quickly. Time is your ally. The emotional consequence of slowing down is control. The punchline is simple. Pause before pen. You should also know that powers of attorney can be customized. They are not one size fits all. Authority can be delayed. It can be limited. It can require more than one person to act. Many seniors like Louise or Kenneth never realize these options exist because no one explains them. This is why professional guidance matters. The emotional consequence of customization is confidence. The punchline is clear. One document should fit one life. Here's a gentle reality check. If someone pressures you to sign quickly, that is a warning sign, not proof of wrongdoing, not an accusation, just a signal to slow down. Legitimate help stands up to scrutiny. Seniors like Pauline or Victor often say they wish they had trusted that instinct sooner. The emotional consequence is empowerment. The punchline is this: pressure and protection do not belong together. Before we move to the close, let me leave you with one more protective insight. Review your documents regularly. Life changes, health changes, relationships change. What made sense 5 years ago may not make sense today. Seniors like Gloria or Samuel who revisit these decisions feel more in control and less anxious. The emotional consequence is stability. The punchline is simple: documents should evolve with you. Let us bring this together calmly. A power of attorney is not good or bad by itself. It is powerful, and anything powerful deserves respect, time, and understanding. Needing help does not mean giving up authority. Trusting someone does not mean removing safeguards. You are allowed to slow the process. You are allowed to ask questions. You are allowed to protect yourself while still accepting support. If a situation ever feels legally or financially complex, contact a licensed attorney or qualified professional who can give you advice specific to your circumstances. You deserve calm, clarity, and respect. And if this information helps you recognize a pattern or avoid a mistake, share it with your friends, neighbors, or family members who may face the same pressure. Many seniors fall into these situations simply because no one warned them. A simple conversation can protect someone you care about. Carry that forward with you. Your rights do not expire with age.